All right, this is case number 21-161953. This is RT Homes versus Patrice Green. The matter is before the court on the motion for reinstatement. The court also calls 21-161978. There's a motion for reinstatement. The court received a number of these files, and each of them had contained within the document, within the file, a motion indicating we are requesting the court set aside dismissal for lack of progress for the above referenced case because we were unaware the court required proof of service to be submitted after the default request entry and judgment was granted. We are under the impression and assume that the certificate of mailing was done by the court clerk when we submitted the default request entry and judgment. We are asking permission of the court to allow us to file the proof of service at this time and set aside dismissal for lack of progress. And looking through each of the files that I received, I noticed the entry of judgment, but I also noticed the complaints that were filed in each matter that really doesn't give any information regarding what claim is being asserted against the defendant. And the complaints in each of these matters do not seem to be sufficiently pled for the court to grant relief. And so that's a concern that I raised more than the concern of reinstatement is whether or not a judgment should have been granted in any of these matters anyway. All right, so who's here for RT Homes? Who's here for RT Homes? So I have Simona Taylor here. Do I have Patrice Green here? Those matters are set on for 9:30 a.m. I'll revisit those momentarily. The court now calls case number 22-243052. This is Max Chambliss Sr. versus Victoria Park Homeowners Association. The matter is before the court after receipt of answer. This is a status scheduling conference. Your appearance for plaintiff in this matter, or do I have Max Chambliss?
Michael Hayes on behalf of Mr. Chambliss.
Thank you, Councilor. Your P number, if you will, for the record, sir.
75419.
All right, thank you, and good morning to you, sir. All right,
Morning.
I'm calling for Victoria Park Homeowners Association. Council, if you're present, Victoria Park Homeowners Association. All right, Council, Mr. Hayes, you had any contact with the
Mr. He's still muted. He was trying to speak. It's Mr. Alan Penskar. I hope I said his name properly.
Just hit your unmute button or *6. That should get you off, sir.
Alan, you're still muted.
All right, Mr. Penskar, you got to use your superpower now. Your high technological advanced skills.
I don't think he heard you about the *6, Judge.
Yeah, you can try *6, sir, and maybe that'll get you off of mute. And Mr. Hayes, by the way, let me ask you, did you have a chance to speak with this council at all today? Is there any kind of communication?
Your Honor, I'm filling in for my colleague Mark Demarest, but there has been some discussion. One of the things that we've discussed is we do think we're probably going to need to file an amended complaint. This case was removed from small claims court, so it was filed initially by our client, and so not all the claims are sufficiently described in the initial pleading. So we're going to be requesting the opportunity to file an amended complaint. My colleague Mark Demarest has discussed with the defendant's attorney that they're going to be providing us with financial documents and minutes from the homeowners association's meetings. And we would just like 3 weeks from the time that we receive those to file an amended complaint, or either looked, depending on what the claims might end up being, to have the case transferred to the circuit court. I just don't know exactly what claims we're going to be making. So, it's possible the circuit court may end up having jurisdiction.
Mr. Pinsgar, I know that you're having difficulty being able to get on in terms of talking with them. Were you able to hear that discussion? What Mr. Hayes said? Nod your head or something. Let me know. Were you able to hear that discussion? All right. So I think, and Mr. Pinsgar did nod in the affirmative. I think what I'm going to go ahead and do, if it's okay with the parties involved, I'll go ahead and set this up on a scheduling order, and within the framework of that scheduling order, there is an anticipation that there will be an amended complaint file. And of course, I have received the answer of affirmative defenses, and I suspect, of course, that it will be updated to the extent that there is an amended answer file. Also, I will go ahead and formally open discovery at this time so the parties can act upon requests that they may have in regard to discovery, although I know that everything is not completely sequenced at this time, but rather than waste any time, maybe the parties have already talked about perhaps exchanges of information. This will give the formal opportunity to do so. So what I'm going to do is I'm going to set this on a roughly 60-day calendar so we can get back to me, and I'll take another look at it. And that's going to take us over to, I'm actually going to go ahead and set it for February 1st. That period from now to that period, there will be open discovery that will be allowed between the parties. Any amendments that might be filed, you want to do it within that period of time as well. You'll receive a scheduling order from me setting forth the fact that discovery is open through the 1st of February, and allowing you also under paragraph number 6 to submit any motion to the court that you might like for me to make a decision on for hearing on February the 1st. And the rules are set forth in that provision number 6. It simply says that if you wish to file a motion that you want to bring before the court, dispositive or otherwise, you may set it for hearing on that pretrial date, which is February 1st. And when you set it for hearing, all you need to do is give the other party at least 10 days notice of the issues that you're raising. If you give them 10 days notice, I will hear the motion on the 1st. Now, this order will not preclude perhaps the filing of motions in the future, but if in the context of the 20-day, of the 60-day period, you decide or you believe that there's something dispositive or non-dispositive that you wish to bring before the court, then set it forth as a motion. Make sure the other party has at least 10 days notice, and I will hear it on the 1st of February. I just wanted to go over that. That will be set forth in the scheduling order. And again, I know that the case is not, that all of the underlying issues of setting it before the court are not totally established. So when you come back on the 1st, if we need to adjust some things, we'll adjust them and move forward accordingly. But this is to get the ball moving, right? Does that work okay for you, Mr. Hayes?
It does, Your Honor. Thank you.
Mr. Pinsgar, that works okay for you, sir? Give me a nod there. Not able to hear you, but I can see the nod there. All right. So I'll get the paperwork out to you today. You'll get something in the mail from me, the scheduling order from me, and then we'll have the next date. The time for hearing on that date is going to be 9:45 a.m. February 1, 9:45 a.m. And that you'll receive that information in the mail. All right. Good day to the two of you.
Thank you, Your Honor.
All right, the court calls 21-161-983. This is RT Homes versus Dia Sneed, and the court also at this time calls 21-161-998 RT Homes versus Siobhan Pankratsley. Both matters are set before the court together with the suffix 1976 and the suffix 1953 on motions to set aside dismissals under the scenarios that the court raised or set forth on this record on with the previous two cases that were called under RT Homes. These matters under 1998 is RT Homes versus Tankersley, and under 1983 RT Homes versus Dia Sneed. All right, do I have anyone from RT Homes on this Zoom? All right, do I have Siobhan Tankersley on the Zoom? Do I have Dia Sneed on the Zoom? No response, and there are four of those matters that I called and that received a response on any at this point. The court also now calls RT Homes versus Dion Banks. That's under the suffix or the case number 21-162-008. That's RT Homes versus Dion Banks. Do I have Dion Banks on the Zoom? Do I have anyone from RT Homes on the Zoom? RT Homes? No response on that matter at this time. The court now calls case number 06125000. This is Hertzberg Acceptance Corporation versus Eugene Youngbae. The matter is before the court on objections to a writ of garnishment. The record should reflect that a judgment was initially entered in this matter on the 26th of September 2006 for $1,731. That judgment was renewed on the 13th of September 2016. And this is an effort to collect on that judgment that is outstanding. Do I have someone from Hertzberg Acceptance at this time? Mr. Monroe? No, I don't think you're on this one. Let me see. Do I have Yolanda Mason? Anyone on the Hertzberg matter? All right. Do I have Mr. Eugene Youngbae? Mr. Eugene Youngbae, if you're on this Zoom, please say something at this time. And actually, that's set on for 10 o'clock, so I'm going to come back to it in the 10 o'clock spot. All right, I have I can see a Arthur Harvey on the Zoom. And what are you here on, sir? Let's see if we have the other side on your matter.
Motion for possession pending judgment.
All right, what's your case number? You got your case number in front of you?
No, Your Honor, I sure don't. There's not a case number on here.
All right. Sorry.
Oh, like Charles. Who we talking to, Arthur Harvey?
Yes.
984 is the last three digits.
94.
At what time?
10
10
o'clock.
o'clock.
All right, so we're waiting till the 10 o'clock hour for the other side to get it going. Miss Charles, I see a Lola Charles, I believe it is.
Yeah.
All right, and so what matter are you on, ma'am?
Garnishee, along with the third party, my state taxes, federal. I'm sorry.
Okay, so let me, which one? Which case?
It's ended in 228. under 10 o'clock commitment funding. Objection.
All right, got you. You said two.
That's
Oh,
the
yeah.
last 3 digits.
All right, so we're waiting until 10 o'clock so that we can call your matters. All right, given that you're here before 10 o'clock, if I get the other side, I'll call you. I got a number of other cases.
Thank you.
The gentleman with the iPhone, the Christmas tree in the background, what's your name, sir?
Joshua Casillas.
Uh,
Gateway Financial, ending in 334.
all right, got you checked in there, sir.
Thank you.
Can everyone place their device on mute, please? Until the court address you. Thank you.
Hello?
Okay, we need, yes, can you place your device on mute, please?
Oh,
Mr. Young Bey, we need you to place your device on mute also.
Everybody should be on mute. All right, this is case number 22. This is 22-197-984. This is VFCU Financial versus Arthur Harvey Jr. Your appearance matter is before the court. Looks like on a petition for possession pending final judgment. Your appearance for VFCU.
Excuse me? Excuse me,
I
Your
haven't
Honor.
called you yet, sir. I'm looking for the other side. All right, for DFCU, if you're on the Zoom council. All right, Mr. Harvey, I got you up, sir. I'm giving the attorney an opportunity to come in, We're waiting for that.
Okay.
All right, the court now calls case number 13. Case number 06-125000. This is Hirschberg Acceptance versus Eugene Young Bay. Your appearance for the plaintiff on this objection to writ of garnishment, please. Hirschberg Acceptance, please. Mr. Young Bay, we're waiting on the attorney on that matter. I'll call it another again shortly, sir. I'm looking now for case number 13-105-333, Gateway Financial Solutions versus Joshua Cassius. The matter is before the court on the filing of objections to a writ of garnishment for Gateway Financial Solutions, please.
Yes, sir.
Gateway Financial Solutions. Your device has to remain on mute until I call your matter. All right, Mr. Cassius, I know that you're there. I'm waiting for the attorney on the other side of this matter, sir. I'll get back to you in just a moment.
Yes, sir.
Sir, if you come off of mute again, I'm gonna dismiss you from here. Gentleman there with the iPhone, you have to stay on mute. All right, this is case number 15-101-228. Mr. Moore, put yourself on mute there, sir. This is case number 15-101-228. This is Midland Funding LLC versus Lola Charles. Matters before the court on the filing of objections to a writ of garnishment. Your appearance for Midland Funding, please.
Good morning, Your Honor. Jennifer Dillow, P69855, appearing on behalf of the plaintiff.
Thank you, Ms. Dillow. Good morning to you. I believe that I have Ms. Lola Charles on this matter. Good morning to you, Ms. Charles. I know she was here earlier. Ms. Charles. Ms. Lola Charles. I see you up there. Ms. Charles, are you able to come off mute? Hit *6, ma'am. That'll get you off of mute. If you see the microphone on your phone, just hit the microphone. I'm not able to hear you because your device is yet on mute. So unmute yourself.
Your Honor, Shaquille Tinsley checking in.
Don't interrupt my hearing again. Okay, Ms. Charles, are you able to get off mute? Okay, looks like and Ms. Charles, while you're working on that, I'm gonna talk about this just a little bit. This arises.
I'm
out
off
the
of mute.
fact that-
Thank you. I'm sorry.
All right, good job. Good morning to you, Ms. Charles. All right,
Good
looks
morning.
like your objections to writ of garnishment regarding a judgment that was entered in 2015 for $784.97. That judgment remains unpaid. Your document says that I have sought the protocol for debt collection. And then I can't make out all what you're saying as your objection. What were you trying to tell me, ma'am?
I was trying to tell you, Your Honor, is that not only have I tried to resolve this matter from the very beginning, up until now, a lot of things have happened since COVID, and all I've had is the different attorneys coming after me for garnishing. I've asked for the original account. I've asked for a settlement. I have kept them aware. I have returned the vehicle. I've done everything that they've asked me, and they have constantly responded with going after funds that I don't have. And I have many collectors that I am trying to be in touch with, along
Thank you,
with
ma'am.
them.
Thank you. I've looked at it. The problem is, of course, that you have a judgment outstanding against you. That judgment was entered back in 2015. And as long as that judgment is in place, the other side is going to be taking every effort to try and collect on that. Just as if you have judgments anywhere else, they're gonna try to collect on the judgment. Whether they're successful or not will depend upon whether or not you have any resources. But if there's a judgment in place, the law allows for an entity or a person to go after trying to collect on that judgment. Let me hear from the other side on this, from Midland Funding. Let me hear from you, Mr. Dillon.
Good morning, Your Honor. On this case, the defendant objected to the 2022 tax garnishment. I wanted to advise the court today that on November 15th of 2022, we received tax garnishment money from last year's filing, and that those funds paid off the garnishment or paid off the judgment. So with that, on November 21st, we prepared and sent to the court. I don't believe the court has a satisfaction of judgment. And on November 23rd, we sent to the court a release of the 2022 tax garnishment. So at this point, the judgment's paid, and we do not intend to move forward with the 2022 tax garnishment.
All right. What that means, of course, Ms. Charles, is that you are paid off here in this garnishment that was brought against your income taxes for the coming year. It's moved, so that you won't be garnished in the incoming tax year. Whatever they received before has satisfied your judgment. You should receive a document shortly indicating that this judgment is satisfied. So you shouldn't hear about this judgment anymore.
Here's the thing, Your Honor, and
No, here's the thing. Here is the thing. The thing is that this case is over with. You may have a lot of other debt collectors that you need to go and deal with. You can go and deal with them. The only issue in front of me today is whether they could garnish your income tax return that's coming up this coming year. The answer to that is no. So that makes
okay,
this case over with. If you have some other things that you want to raise, you have to file another kind of motion to do that. But the issue that's in front of me today, you won because this is over with. They can't collect anything against you on this case anymore. Because this
because
case is
I
over.
have 2 judgments in there from them, and I understand you now.
Not in this case, not in this case. And I understand. I'm not trying to cut you off too much, except for the fact that I got a bunch of other people to go to. If I had listen to me, if I had 2 cases in front of me, if I had both of your cases, I would be dealing with both of your cases. Only have 1 case. And this case is over with. That's the end of this. If your other case comes up, it may be in front of another judge. If it comes up in front of me, I'll do that at that time. I can't deal with that because that's not before me. Okay?
I understand. I understand.
This case is closed out, and I wish you the best, ma'am. Thank you, counsel. Good day to both of you.
Thank you, Your Honor.
Okay, do I have Gateway, counsel on Gateway?
Thank you.
Do I have counsel on Gateway? Do I have counsel on, for Hirschberg? Do I have counsel for Hirschberg? Do I have counsel for DFCU? Do I have Eugene Green on this zone? Say something if you're here, Mr. Green.
Yes, sir. Yes, sir.
Thank you, sir. All right, you can mute yourself again. Do I have Gateway Financial Solutions? All right, this is case number 16-114-608, auto, strike that ADC Auto Finance versus Arnell Moore and Terry Moore. The matter is before the court on the following objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter for the total sum of $10,408.25. That was in 2016. Your appearance for ABC Financial.
Good morning, Your Honor. Robert Zelinski on behalf of plaintiff P 69250.
Thank you, Mr. Zelensky. Good morning to you. I'm looking now for Terry Moore and also Arnell Moore. If you're here, say something to me.
I'm here, Your Honor.
Thank you, Mr. Moore. I do see that you are that you're here on this matter, sir. All right, so you filed objections to a writ of garnishment. There appears to be an outstanding judgment against you. You put on the objection, I do not owe this, but there's a judgment against you, sir. So until that judgment is set aside, it's something you do owe it, and they have an outstanding judgment against you. Talk to me, Mr. Moore.
Yes, I've got some new information, and I checked for auto finance. It doesn't exist. I called the place, the company that I purchased the truck from, and they say they'd never heard that company before. And I paid the truck off like years ago. Then they come after me again. I paid the truck off like 7, 8 years ago. I don't understand why this constantly happening to me. I've been dealing with this case here, well, a different case, the same attorney, almost 20 years now. But the auto finance company do not exist.
All right, so it sounds to me that what you're doing is you're saying that there is a basis to attack the underlying judgment, and the court rules do not allow you to do that in a post-judgment proceedings. And there's already a judgment against you. If you believe that there is some reason that that judgment should be set aside, then you have to file a proper motion of paperwork to bring that before the court to raise that issue. Today, the only issue before the court is whether or not there is an outstanding judgment and whether the garnishment or whether the plaintiff can garnish on that judgment. And there is an outstanding judgment, and they have effectuated a garnishment. Now, Detroit Golf Club, is that the place where you work, sir?
Yes, sir. Yes.
Let me hear from the other side on this, please.
Yes, Your Honor. We were here on August 10th. Defendant filed an objection to the garnishment. It was a similar situation. What happened then was we had agreed on a payment order for the defendant, and Your Honor entered. He marked the objection invalid, and we subsequently emailed a proposed payment order to defendant and never received that back. And he actually, I'm looking at my notes, Attorney Katz from my office called the defendant, talked to him on September 27th. He said he would call back regarding the payment order, and he never did. So we filed a fresh garnishment.
Yeah, Mr. Moore, you're gonna keep getting garnished in your wages if you either you got to try to attack it by filing some motion to try to get the judgment set aside, or you've got to come up with some type of payment arrangement. Otherwise, you're gonna get hit every pay period.
Yes, I'm trying to come down to court and find some more paperwork because I feel like I do not owe this. This has been going on so long, and I don't understand where they're coming from with this amount. It was no 10,000, it was 9,000, and like we had come to a type of agreement. Then I found out that auto finance don't exist. They try to gunch me. That only person I ever had dealing with credit exceptions. Never deal with no auto finance. That's only my biggest problem is because that don't even exist. So how they gunge me for auto finance?
All right, well, I have no idea, but I suspect that your debt was likely sold to another entity, and that other entity that bought the debt is the one that's collecting against you. Those are questions, obviously, if you want to raise them in a motion, you can file that before the court, and that will be set on for hearing.
Yes, sir.
As it relates to the objections to the writ of garnishment, I don't see a valid objection. Therefore, I'll find the objections invalid. Any funds withheld will be released to the plaintiff. If you wish to get some relief on the payments, you want to file a motion for partial payments on the second floor, and the court will consider any motion for partial payments. Motion for partial payments could reduce the amount that you have to pay on a monthly basis so that it's not taking 25% of your income, because that's what the garnishment would do. All right, I wish you well, sir. Good day to you.
Thank you, Your Honor.
Thank you.
Can I talk to you? This shit was a bust. I got a lawyer. Tell me to find one. I go back down there.
Every mic should be muted at this time, please. All right. This is case number 22191. Start that 22197-984. This is VFCU Financial versus Arthur Harvey. The matter is set on 10 o'clock a.m. Regarding a petition for possession pending judgment based upon a claim and delivery complaint that was filed before this court for VFCU Financial, please. All right, do I have Mr. Harvey, Inspector Arthur Harvey Jr. on the Zoom? Say something at this time, sir.
Yes, Your Honor.
All right, good morning to you, sir. It looks like the plaintiff wants to recover possession of a certain 2013 Cadillac Escalade, and they filed a petition to have the vehicle recovered. It is in the order that the court issued. It said you should refrain from damaging, destroying, concealing, etc. the vehicle. And then I set a hearing date on it for today's date. Have you heard from the other side regarding this since the time that the court issued this order?
No, sir, Your Honor. I reached out, tried to call them, and I never got a call back. But I don't understand how they sent this petition, because when the matter presented itself as far as my car note, I sent them the money for my car note, and I paid the attorney people, Kenneth A. Tardy and Associates. I paid them and DFCU, so I don't know how it came to this.
Well, there's a lawsuit that was filed against you. It doesn't look like you've answered the lawsuit. Are you going to file an answer to that?
I never knew anything about a lawsuit.
Yeah, there's a lawsuit that's filed against you, and that lawsuit, let's see, tell you in just a moment. They are suing you for, tell you the amount. They're suing you for $23,057.90. They're saying that the contract for the sale of the vehicle was breached, and that therefore they are entitled to pursue judgment for that amount. And they're also asking that they have the opportunity to take the car and dispose of it so that they can use that as against the debt. and wanted to do that in advance. So you're gonna need to file some type of answer to that. Again, let me ask you, I have DFCU on the Zoom. All right, so today, with regard to the hearing, as to whether or not they can take the vehicle, pending, judgment in this matter, I'll deny the motion, at this time where the plaintiff did not appear on the motion. That motion, to recover possession, forthwith, that motion is denied at this time. They could refile that motion and the court would have to consider it. And so you'll want to be watching out for that. But at this time, they can't take the vehicle from you. But there is a lawsuit that you want to file an answer or something to that matter. So I do wish you well. Good day to you, Mr. Hart.
Thank you, Your Honor.
All right, this is case number 15-116598, Gateway Financial Solutions versus Eugene Green. The matter is before the court on objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter on the 10th of December 2015 for $9,110.73. Do I have Gateway Financial on the Zoom?
Yes, Your Honor. This is Attorney Jay Baig, BAIG, P36820, appearing on behalf of plaintiff and the attorney of record. And I apologize, Judge. I have 4 at 10 o'clock, and I just got done with Judge Hinnett Johnson's 9 o'clock. So I don't know if you called any of my other cases, but
Well, I'm sure I've called other ones, and I don't appreciate the preferential treatment with other judges that are not as smart or good looking as I am.
I think that
I'll take it this morning. All right. Do I have you? I'm being facetious for the record. I have Eugene Green there. Is that correct?
Yes, sir.
All right. Thank you, Mr. Green. Thank you for your patience this morning. Mr. Green, you filed objections to a quiz going on there, Mr. Green. So you didn't put down anything that was the basis of your objection. It looks like you got a judgment. They're trying to intercept your income tax return for the state next year. You didn't put down any reason why they shouldn't be able to collect on this judgment. Tell me what your thoughts are.
Well, I don't even know what vehicle they was trying to garnish me for.
And neither do I, but I do know what judgment they're garnishing you for. The judgment was entered, like I told you, back in 2015, and that was for $9,110.73. So this judgment, it's been around for a while. I'm saying the judgment, that is. The
Hello?
case, are you hearing me?
Yeah, I can hear you now.
Yeah. So I was saying that this garnishment is because there's a judgment against you. That judgment was entered against you back in 2015. So I don't know which vehicle it was, but that's the judgment that we're dealing with. If you believe that judgment, that there's something wrong with it, you have to go and file something to try to get that judgment set aside if that's what you wish to do. But right now, you haven't provided me any reason as to why they shouldn't be able to garnish that income tax return.
Yeah, they got the vehicle back.
Yeah, they probably sold it and
yes, they did.
And
yeah,
the difference between what they got for it and what you owed under the contract is what they sued you for.
There's nowhere possible. I was never late on the car note. The car was the truck was in got hit parked by a beer delivery company in front of my house. I contacted the lawyer. I had a lawyer at the time. The lawyer advised me do not get the truck fixed. We was going to sue the beer company that hit the truck because my daughter was sitting in the truck when it got hit as well. It was parked, not running.
Okay, let me stop you. Nothing about what you're telling me right now can I take into consideration because this is post-judgment. You're talking about things pre-judgment. If you want to deal with those pre-judgment issues, if you believe that you want to raise those issues, you have to file a motion and raise those issues. That's why when you filed your objections to the garnishment in this matter, not the judgment, filed your objection to the garnishment, that's why I gave you categories of A through F to put down what the nature of your objection was, because you can't attack the judgment when the issue is the garnishment. If you're going to attack the garnishment, you have to go back to court, file some type of motion to ask that the judgment be set aside or whatever you believe should have occurred in that underlying case. But until that occurs, you have a judgment against you, and the garnishment is happening because you have a judgment. So it doesn't sound to me that like you have a real basis to object to the garnishment. You may have a reason to attack the judgment, but that's not in front of the court today. Let me hear from the attorney on this. Mr. Begg, let me hear from you, sir.
Your Honor, I think you made my argument. Objections are invalid. He's trying to attack the underlying judgment. Thank you.
Yeah, I didn't mean to make any argument for you. I'm just stating what the law is on this, Mr.
Yeah, well, that's my argument.
Okay, thank you, Mr. Green. Yeah, that's about the size of this, sir. It sounds like you want to attack the judgment, and you can do that. You have to file your paperwork on the second floor, and you're not dealing with the garnishment. You're dealing with the judgment. If you get the judgment set aside, then any garnishment and any money that's been taken from you would have to be refunded. But that's where you have to go, is to try and get the judgment set aside if that's what you believe is a problem. All right. So I would have to, based on everything I've read, heard from you, and what happened with this case, I find that the objections are invalid in this matter. In fact, you've not stated an objection, and any funds that might be withheld from the garnishment will be released to the plaintiff. And again, if you wish to, you have the right to file the proper paperwork to attack the judgment if you wish to do so, sir. All right, I wish you well.
Not a problem.
All right, all the best.
You too.
The court calls 13-10-5333. This is Gateway Financial Solutions versus Joshua Casillas. That is before the court on the filing of objections to a writ of garnishment. This is in regard to a judgment that was entered on the 6th of June of 2013 regarding, I'll start that for the total amount of $6,489.76. And counsel, I believe, Mr. Begg, that you're on this matter. Is that correct, sir?
That's correct, Your Honor. Good morning.
All right, thank you. Your appearance is accepted as previously indicated. I believe that Mr. Joshua Casillas is on the Zoom as well. Good morning again to you, sir, and thank you for your patience. Where are you? Mr. Casillas, I know that you were here.
Yes, sir.
All right, good morning, Mr. Casillas. So you filed objections. I'm looking at the items A through F. You put a check mark, and F, you says the writ was not properly issued or is otherwise invalid. What do you mean by that, sir?
I'm sorry, I was a little confused when I was filling that out. I basically have been paying for the past year, and the lady I didn't really understand, but the balance seems to be off. I'm still currently getting balances for $12,000 from them, which doesn't seem accurate.
All right, well, if you got a judgment that was entered at 6489 and back in 2013, if you didn't pay on it for several years, the interest at 13% has probably doubled that amount for sure. So how long have you been paying on this judgment?
I've been paying the last 10 months. I've paid over $2,000 on that judgment. And every week I get letters to my grandma's house saying that I stole $12,000. I recently just picked one up yesterday.
That's probably accurate with 13% interest. That's the problem, it's 13% interest. Let me talk to Mr. Begg. First of all, on dealing with the objection to garnishment, let me ask you, are you voluntarily paying under some consent, or how is it that you've been paying over the last 10 months, you're saying?
It comes directly out my check. And it goes, I believe, the owner of the pizzeria that I manage, he sent me a letter. I didn't object to it or anything. I've been paying it, but they're still currently.
So you got garnished. You got garnished starting 10 months ago is what you tell me.
Yes, sir.
And they're taking the money ever since, correct?
Mm-hmm.
How much, you get paid twice a month, is that true?
I get paid weekly.
Weekly? And so how much are they taking out of your pay weekly, do you know?
Like $50-$60.
Okay, so around 200 plus a month is what you're telling me, correct?
Yes, sir.
Okay, let me talk to Mr. Bay, sir.
Your Honor, I'm looking at a ledger here. As of November 28th of 2022, the current balance owing is $12,631.28. And yes, Your Honor, you're correct that much of it is due to interest. So far, it looks like approximately $8,074 of interest is accumulated on this.
$8,000.
$74.05. It looks like that's the portion of the 12,631.28. That's the interest portion of it, and the principal portion of it is 4454.74.
All right, yeah, that's Mr. Casais, that's a problem. That's the problem. It's interesting. The only thing I can say is that oftentimes when something is lingered this long, if you are in a position to try and resolve it, sometimes the other side will negotiate some of that interest away to try to get it resolved. But you have to be in a position to kind of talk about that and see if you can reach some number to deal with that. The garnishment that's in front of you today is different from the week by week, month by month garnishment. So you have two types of garnishment, one that affects like a wage garnishment, and then the others are garnishments like garnishments against bank accounts, garnishments against income tax returns, things like that. There are two different types of garnishments, and the law allows for both types of garnishments. So the reason that you're getting the garnishment for the State Department is because that's a different type of garnishment. And even though you're paying under the other one, they can file against the state income tax return. So what I'm going to, I don't see a valid objection to that, but I do see that you are paying, you're paying under the garnishment, and it sounds like you're doing the best that you can with that. I have to find the objections invalid. I'm going to see if Mr. Baig will talk with you for a few moments at a breakout to see if there's a way to find what might be a finish line here, because he is paying the 200 a month or so, and then this garnishment is in place. Maybe there's a way to at least talk about how you could see where the finish line is on this in some kind of way.
Your Honor, for this one, I don't have any settlement authority, but I would suggest that he call plaintiff's counsel Scott Schisler. Mr. Schisler is a pretty reasonable man, and I'm sure they'll be able to work something out.
All right, well, I would suggest that you try to do that only because I know that you're trying to pay this off. And if for some reason you're not able to get something worked out, then file another motion and ask for a hearing on the account. Go to the second floor, file a motion for a hearing on the account, and I'll bring it back, and I'll listen to both sides to try to figure out if there's a way to get you to a conclusion. It's almost 10 years on the judgment. A lot of interest has accrued, and the law allows that, but there may be a way to get it worked out. If there is, I want to see if we can find that. So call Mr. Chisler's office, see if you can get something worked out. If not, file a motion and let me talk to both sides at that time and see if there's a way forward. Mr. Casais, I do wish you well, sir. All the best to you. Thank you, Councilman.
Thank you. I see you also have that Hirschberg versus Young Bay. That's mine, but I'm just wondering if.
Just a moment, sir.
They also have that credit acceptance versus effort.
You're talking too much, Council.
I'm sorry. I'll shut up.
Here's the case I'm getting ready to call. It's 06-125-000. I called it about 3 times previously, and Mr. Eugene Young Bay has been here. This is Hirschberg Acceptance Corporation versus Eugene Young Bay. The matter is before the court on the filing of objections to a writ of garnishment. This is in regard to a judgment that was entered. That judgment was entered in 2006 and renewed in 2016. The judgment amount upon entry was again 1731. Looking at the objection, it says a ruling was made on 4/18/22 in my something, my case or something. I don't know what that last word is. All right, you've entered your appearance, Mr. Bay, on this matter. Is that correct, sir?
That's correct. Good morning, Your Honor.
All right, good morning. Mr. Eugene Young Bay, where are you, sir? Good morning to you again.
Good morning, Your Honor.
Thank you, sir. So I can't make out what that last word is on your objection. You said the judgment has been paid, number one, and then number two, you said that a ruling was made on the 4/18/22, on 4/18/22 in my, and then I don't know what that last word is on it.
In my behalf, I'm sorry, Your Honor.
Oh, that's what that is. Behalf. Okay, got you.
Yeah.
That's not behalf, but I'll believe you. It makes sense.
Well, that's what I meant to say, Your Honor.
Got
In my behalf, by you.
All right, not a problem, sir. So, so you're saying that this judgment is paid off, that it's already been resolved or something? Go ahead, talk to me.
This has been resolved. This company, this attorney office, they come at me every 8 years or so, as you say. It's been over 30 years. This case, what they had even took the case to federal court. Federal court ruled in my behalf. This was a government loan for an educational loan when I was in school. It started off at $500. They be charging entrance. The government is not receiving any money on this. They're receiving all of the money whenever they have taken 4 or 5, and it's on record, income tax before I started filing. My wife had a household, and they continue to come back at me. And when you made your decision last year for the 21 taxes, and it was in my favor, they waited until this year, a couple of months ago, to send the paperwork out, and the paperwork was a past month due that they sent me. So knowing what it is that I did prior to this, I came back down and filed a request writ for garnishment income tax refund, or what, objection to garnishment and notice of hearing, just to keep myself ahead of what you might call ahead of the game, or to stay abreast to it, because like you dismissed it last year.
No, I didn't do that. I don't have any, I'm looking at the register of action now. I don't see where I dismissed the case.
No,
let me stop you for a moment. Let me stop you where I dismissed the garnishment, order for something. I'm looking at the register of action, but would have been put in the computer. Just one moment, scheduled. I don't see any action that the court took on this, on the garnishment from last year. Let me hear from the other side, and I'm gonna come right back to you, Mr. Young.
Okay,
Counsel?
thank you.
Your Honor, my understanding was the first, the initial objection was denied. There may have been some confusion about the paperwork, but I'm looking at a ledger right now, and as of November 30th of well, as of today, it's his total balance is $3,047.22, and again, you know, we're talking about interest being accrued, and that's really, that's a major portion of it. It's been years.
All right, so was there, I see that there was a garnishment as it relates to the income tax return last year. Was any money received at that time?
Let's see, I am not showing anything on this ledger. I'm seeing it looks like a $554 payment back in 2006.
All right, so, and here's what I'm looking at now. I was looking at the 2021, I'm looking at 2022 now. In 2022, in May, objections to garnishment held, objections are denied as invalid, immediate release funds to the plaintiff. Then subsequent to that time, I also see objections to garnishment filed, and a hearing was held on the on those objections. It says objection to garnishment held, objection to garnishment granted, objections are valid, immediately release all funds to the defendant. Then that was, looks like that was 5/18/22. In 5/10, I see the motion, a motion filed to set aside objection for garnishment. On 6/14/22, an order entered to set aside the 5/18/22 order on objections to garnishment, and then copies mailed out. So there was a point at which the objections were granted, and then the objections were set, the granting of those objections was set aside in June of 2022. Let's see, go a little further here. And then that brings us up to where the case is now. So Mr. Bay, your statements are true that at one point last year, I did conduct a hearing on this and I granted the objections. There was a motion to set those objections aside. And after hearing the motion, I did in fact set the objections aside and allow the garnishment. The critical issue here, sir, is that there is an outstanding judgment. That's the issue. As long as that judgment is outstanding, that judgment gives the plaintiff the right to file garnishments in an effort to try and collect them. And moreover, that judgment that remains outstanding continues to accrue interest, which, there's a lot to be said about that, but the law does yet allow there to be the accrual of interest on judgment. That's the crux of this, is that there's still a judgment. You may believe that you have a basis to get the judgment set aside. If you want to file paperwork, a motion to set that judgment aside, a motion saying that for some reason that you do not order or it shouldn't have been entered, you could certainly file that motion, but until there is something that sets that judgment aside, the plaintiff has the right to continuously try to collect on the judgment that remains in place. And it remains in place up to this time, sir.
Okay, well, Your Honor, if you will hear me out, like I stated, you see how far back this judgment go. Originally, it started off at $500 and something.
Okay, well, I heard you on that. Let me stop you, Mr. Beck. I heard you on that. You told me that happened. You said this has been something dealing with 30 years ago, and et cetera. I can only go back with regard to this case in 2006, because that's when it was brought before the court. All the things that may have happened before then are not issues that I can address. However, if you wish to file a motion and address those issues, you can put those in writing, and I'll file a motion asking that the judgment be set aside for various reasons. But the only thing that the court has in front of it is 2006.
Okay, Your Honor, I understand. Well, would you tell me what is the process of me doing this to do what it is you're speaking on right now, to have this set aside, because this has been paid a long time ago. And believe it or not, I'm what you call a paper hoarder. I have the paperwork from the federal court, and I have the paperwork from 36 district court, and the paperwork where they file every 8 years, every so they'll die off for a minute. I don't have to worry about anything. Then I have to end up filing whatever form that is that I didn't have to form when you made the release last month. All I want to do is squash this, because the government is not getting no money. I paid them off for what the loan originally was a long time ago. And I'm tired of these people.
Let me stop you for a moment. And this is why, I try to give people opportunity to talk because it's important. I want to hear what you have to say. But I know, Mr. Young, that you can hear yourself telling me the same thing that you told me about 4 or 5 times already.
All right.
I heard you the first time. And I'm
Okay.
not trying to be rude to you. I heard you the first time. I'm telling you
Okay.
that if you've got an order from federal court, if you've got a satisfaction of judgment, if you got something showing that you paid this off, file a motion, attach all of that to your motion and show that you have paid this off, that you satisfied the judgment, and or that there is some order that you have from federal court that shows that this whole matter is resolved. And that will be dispositive to this case. I mean, it takes something on point to do that. You already told me those things, but you have.
Okay. I'm sorry. I'm sorry for repeating myself, Your Honor.
That's okay. I just want you to know that I heard you. I'm not, I understand
Okay.
people repeat themselves. I mean, I come from a family, I'm one of 9 siblings, so there gets to be a whole lot of repeating that takes place, especially during the holiday season. But, so I'm not angry about it. I just want you to know I heard you. And then you gotta know the approach you have to take, in light of the fact that I heard you. The approach that you have to take is to file the proper motion. And that motion is not just objecting to the garnishment. You got to go after the judgment. You got to try to get that judgment set aside. And you say you have some reasons why it should be set aside. So
yes,
for
I
the
do.
reasons that I've indicated, I don't see a basis for setting aside the garnishment. But again, if you are able to get that judgment set aside, then any money taken from you under any garnishment or otherwise would have to be refunded if the judgment is set aside.
Okay.
All right? I wish you well, sir. All the best.
So
to you.
where would I come and what paperwork would I ask in order to file this motion to have this set aside?
You go to the 2nd floor of 36 District Court is where you want to do your filing. And you might want to consider a motion to set aside a default. I can't lawfully give you legal advice as to how to do that. But it sounds to me that that's what you want to do, that there's something that you want to file as a motion to set that aside. That's what you would want to consider.
Okay. All right. Thank you, Your Honor. And you have a
Thank you,
blessing.
sir. Good day to you.
Bye.
Thank you, Judge.
All right, Mr. Baig, any other case you had in front of me?
Yes, credit acceptance versus effort, and I see in the chat that the defendant is there.
This is case number 18-151023. This is Credit Acceptance Corporation versus Deidre Efford, E-F-F-O-R-D. The matter is before the court on the filing of a writ of garnishment. Looks like I received, this is 2019, the garnishment released back then, but the present garnishment is asked to the Michigan Department of Treasury. There's also a garnishment with regard to Michigan First Credit Union. Defendant has filed objections to both, and as indicated, I did not get served or receive a court date on the original case, and the case was not attended or something along those lines. Those issues regarding the underlying case are not issues that this court can take into consideration. All right, Mr. Baig, I've received.
Can you repeat that again? You said Deidre?
I haven't come to you yet. I haven't come to you yet. So, Mr. Baig, I've received your appearance. I'm looking now for Ms. Shanta Efford. Good morning to you, ma'am.
Good morning.
All right. So, Ms. Efford, I looked at the objection that you raised regarding both of these garnishments, and the objection has to do with something about the underlying case, and you can't attack the underlying case in a post-judgment matter. This is only about the garnishment, not about the case that was filed, when there was a judgment entered against you. This case has been going on since 2018, apparently. The judgment was entered back in 2018 for $13,331.66. So if you believe that that judgment should be set aside, you have to go and file a proper motion in that regard. I will tell you that contained in the court's file is an affidavit of service where a process server indicated that they served you on April 12th, 2018, at 1885, sorry, that 188, 57 Eureka, and that they served the complaint on. When you received a complaint, you would not receive a court date. You had 21 days to answer that. If you didn't answer it within 21 days, then thereafter a judgment would be entered by default. That's what likely happened in your case. So go ahead, ma'am. You had something you want to tell me, please.
Yes, because I have all the paperwork right in front of me for that case. I never got served. I got a statement in the mail saying that I owed that money. The judgment was actually, it was taken off of my credit and then it was put back onto my credit. Not only that, I have a registration that's not signed by me. I have a purchase agreement that's not signed by me. None of these, I couldn't even get I didn't even have a license. I couldn't get a car registered in my name during the state. I had all these documents and more, but like you said, that's pertaining. I have to go down there and do something else. I thought that's what I was doing. I was informed wrongly, clearly.
No, I don't think that you were informed wrongly or anything. I think that you simply don't know how these things operate, and that's
right.
okay.
I need to get a lawyer.
That's nobody's job to inform you of that. But it makes sense that you would not know that because you're not a lawyer. I understand.
Right.
But but understanding that, I want you to understand now the issues that are involved. And you have a judgment against you. Because there is a judgment against you, that's why there is a garnishment. They file, because if they don't have a judgment against you, they can't file a garnishment.
Right. It was a wrongful judgment, though, sir.
You can't, whatever you do, you can't cut me. You can't. You just can't. Not because I'm good looking and handsome and all that, but because the law puts me here as a judge. You can't cut me. Okay. So it seems that there are a couple of things that you want to do. And the main thing that it seems like you might want to try and do is get that underlying judgment set aside. The problem is that judgment that was entered against you was based upon a complaint that was filed against you. And that complaint says that there was a breach of contract arising out of a retail installment contract. Looked like there was a vehicle purchase at Joey's Auto Sale or something. That's where all of this is coming from. All right.
I know exactly where it's coming from.
Okay. I thought I would just mention that because I don't know.
Yeah, because I have all the paperwork. So I know.
You'll cut me off again. You must think you look better than me.
Oh, no.
I'm being facetious here. But my point is that you may be able to go back and try to attack some of that. But right now you have to deal with the post-judgment stuff because that judgment is in place at this time. On the Michigan State Treasury, that's dealing with what you might receive as a Michigan income tax return if you file your taxes. That's what that one's dealing with. The other one is Michigan First Credit Union. Is that where you work or is that where you bank?
No, that was a bank.
Are there any funds in that account?
No.
So it doesn't matter with that.
It made it negative though, because now I have to pay because they garnished it. So what you got my credit be looking bad. It's not good on my credit.
Got it. All right. Mr. Bays, let me hear from you, sir.
Yes, Your Honor. I think the objections are invalid as you indicated. She's attacking the underlying judgment, but for whatever it's worth, I see the retail installment agreement and she's got her signature on it. So
well, she could certainly, ma'am, you certainly, if you believe that there's a reason to have that set aside, the sooner that you file something, the better. And to try and object to it, it's already been a few years.
Too long.
You find something better, all right. But I don't see a valid objection on the garnishments. I'm looking for one. I just don't see one. but you may have something that you can advance on the underlying judgment, which you have to file a proper paperwork.
Okay.
Right? So
Where do I do that?
You do that on the second floor, the same place that you file these documents. And it sounds like what you want to do is file and say that you believe that that judgment should not have been entered. And file some paperwork and put the reasons down as to why you believe the judgment should not have been entered. And then a hearing will be set regarding those matters. All right.
Thank
So I don't
you.
see a valid objection on these matters, and I really will be consistent therewith. So any funds that are withheld will be released to the to plaintiff to go towards satisfying the judgment. Again, if you get the judgment set aside, any money taken from you will have to be refunded to you on this effort. I do wish both sides well. Good day to both of you.
Thank you.
And thank you for accommodating me, Judge. And just for that, I'll say that you're almost as good looking as the other judge.
All right, we'll leave it at that. How about that?
All right, thank you.
All the best. All the best to you, Ms. Alford.
Okay, thank you.
Thank you.
I'm looking now for case number 18-163-075. This is Credit Acceptance Corporation versus Danielle Lindsay. The matter is before the court on the filing of objections to a writ of garnishment. There's also a motion for partial payments that have been submitted to the court. For the plaintiff, your appearance at this time, please.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Thank you, Mr. Warber, and good morning to you, sir. I'm now looking for Ms. Lindsay, Danielle Lindsay. If you're on the Zoom, please say something at this time.
Good morning, Your Honor. I'm here.
All right, good morning to you, ma'am. This matter arises because there was a judgment that was entered for $7,054. That was back in 2019. I see that you objected to the garnishment of Liberty Security Group Incorporated. Is that where you work, ma'am?
Yes, correct.
Okay. Has any money been garnished, taken out of your check as of yet, ma'am?
Yes, out of my last check, I believe it was close to $200. I think maybe $197 and change.
Okay, approximately $200. What do you get paid every other week or every 2 weeks, or what is it?
Every 2 weeks.
Every 2 weeks. Okay. So the garnishment would roughly be getting you for about $400 a month, right?
Pretty much so.
All right, so you stated that the funds property was exempt, protected by law. Do you believe that the funds are protected by law or exempt?
Honestly, I kind of really didn't understand because this is my first time in court for something like this, so I'm a little lost. I will say that. So I may have put the wrong thing down. I just know. I'm sorry.
So basically, it sounds like to me what you want to do is find a way to pay on this without getting garnished and have a partial payment plan going forward. That's kind of what you want to do.
Yes, I do. Because when we initially got this car, me and my ex at the time, we were young and we got this car from off a lot. We didn't really know what we were doing all the way. We didn't have a warranty, and the car ended up being a lemon. It gave out on us about a month and a half after buying it. We did make about 3 to credit acceptance, but then we were too busy trying to get it fixed because it ended up being a lemon. We tried to go through with the lemon law, but we lost patience. And then with us being young, we just kind of forgot about paying it and kind of let it go, let life go past. But as the last year and a half, I am 31 now, so I have been trying to take care of anything that's on my credit. I don't have a lot of debt, but I just want my name clean. I'm not denying this. I will take care of it if I'm able to. So that's the case.
All right, Mr. Werber, I don't see a valid objection to the garnishment, but the defendant has offered to start making payments voluntarily in regard to this matter. Let me hear from you, sir.
Yes, Your Honor. The only problem I have with that is back in 2020, we had a wage garnishment and we released it to put the defendant on a payment plan of $100 a month. We didn't receive any payments whatsoever on that. The only payment we've received on this 2019 judgment is $394.19 from the garnishment just last week. There's been no voluntary payments made at all. So normally I always give everybody one chance to make voluntary payments. The defendant didn't make any payments as agreed. So I'll let you rule on that, Your Honor.
So what happened back then, Ms. Lindsay? I do see a garnishment, at least you're working for power maintenance service or something?
Yes, at the time, if I can remember, I do remember getting something like that, but once again, I do believe that I said in my mind, I said that I would take care of it, and I think I just kind of forgot. And at that time, that job was literally a part-time job. I literally wasn't making enough to even take care of it. Like I thought that I would be able to, but like I said, now lately, I am able to take care of it. I'm more financially responsible with my money. I'm making enough. So I am willing to take care. Back then, I didn't really have enough to take care of it like I thought I did.
All right. All right, under the circumstances, I don't see a valid objection, so I will determine that that there is no valid objection, and any funds withheld will be released to the plaintiff. I will suspend the garnishment, ma'am, and I'll give you a chance to take care of this. By suspension of the garnishment, that simply means that you make the payments and the garnishment stays suspended. If you don't make the payments, and the garnishment will be reinstated. I can tell that you're trying to get on your feet, and I respect some maturity that occurs, especially since I've got a 27-year-old, 28-year-old, and a 32 and a 34-year-old. So I do see them grow up, and they do sometimes make some mistakes that later on they don't make those mistakes again.
Yes.
So we'll give you a chance to try to do this. Remember, this is on you. And it will work, but you gotta stick to it. If you don't stick to it, you'll be right back in the same place. And given that this is something that I'm ruling on, in this case will remain with me. If you come back and you're not gonna keep it, then I'm just gonna let the garnishment stay in place. And I don't want to see you have to deal with it like that, because I'm sure you got other stuff in life. I'll go ahead and set it up this time. So I'm going to set the payment, ma'am, at $125 a month, and I'm going to start that payment. We'll set it the 30th of December, 2022, and so the last Friday of the month thereafter will be, you want to get that payment in, $125 a month. The funds that have already been taken, those funds will be released over to the plaintiff to be applied towards the judgment. And then you start the voluntary payments December 30, 2022.
Okay. Thank you so much.
All right, we will send the paperwork out to you. Once you get that paperwork, make sure you take it to your payroll because it will have the proper information for them to stop or to suspend the garnishment. All right, thank you, counsel. Thank you, ma'am. Good day to you.
Thank you, Your Honor. Have a good day.
Let's see. This is 19-171-242. This is Reliable Auto Finance versus Jamie L. Davis. The matter is before the court on the filing of objections to a writ of garnishment. Your appearance for Reliable, please.
Good morning, Your Honor. Jeremy Chisholm's P74670. I'm the attorney of record for the plaintiff.
Thank you, Mr. Chisholm, and good morning to you as well, sir. I'm looking now for Jamie Davis. If you all assume, please say something at this time. Jamie Davis. All right, I'm looking for Jamie Davis on Cocos Lawn Street in the city of Detroit. All right, it looks like the objection to writ of garnishment, I do not have money, but enough, do not work enough hours, not working enough hours, is the objection as stated here. That would not raise a valid objection. Maybe the petitioner was looking for perhaps an opportunity to pay voluntarily, but petitioner has not appeared. I'm asking once again for Jamie Davis. Jamie Davis, if you're on this Zoom, say something. Given the failure of the petitioner to appear and the objection seeming invalid on their face, the court will deny the objections as invalid and will sign an order releasing any funds to the plaintiff, and the garnishment will be continued.
Thank you, Your Honor.
Thank you, counsel. Good day, sir. Thank you for your patience.
Thank you. I was on with Judge Giles, and I was going to ask him which one of you guys was more handsome, you know. See if I could get him to play that game.
Hey, you know, you might not want to do that with him. I don't know.
I let it go, Judge.
A little more stern than I am.
Well, it's been very entertaining. I texted my wife, and I was shocked when you said you had a 34-year-old. I said, it's the first time I've been in front of you. I said, this guy's really funny. He's a great judge. And I said, she said, you know, I said, she's about 50 is what I put on there. I think he's 50-ish. And then you said you had a 34-year-old, and I said, oh boy.
I'll be 63 in December.
Well, you are a handsome guy.
I keep making my daughter, my oldest child, 34. She's 36, and her birthday is tomorrow, the 1st. She'll be 37. And she's a judge. She's a judge in Harbor Woods.
Okay, well, that's fantastic. That's fantastic.
So yeah, I've got a few grown folks. And make sure you tell your wife that I have a 37-year-old, a 32-year-old, a 27-year-old, 28-year-old, and a 9-year-old and an 11-year-old.
So, okay, so I thought we were about the same age, and my kids are 8, 10, and 12. And
I almost have kids your age and the age of your children. All right, good day.
Well, Judge, you got a great sense of humor. I've enjoyed watching. Thank you.
That is funny. All right, this is case number 21-149973. This is Michigan First Credit Union versus Shaquille Tinsley. The matter is before the court on the filing of objections to a writ of garnishment. This is regarding the state income tax return, State Department of Treasury. All right, counsel, your appearance for Michigan First Credit Union, please.
Good morning, Your Honor. Weston Neal on behalf of Michigan First Credit Union, P number 80307.
Thank you, Mr. Neal. Good morning to you. Thank you for your patience this morning as well, sir. I'm looking now for Miss or last name Tinsley.
Yes, Your Honor. I'm here.
Right.
I apologize for interrupting earlier. I couldn't hear.
Oh, that's okay. What's your first name?
Shaquille.
All right, thank you, Ms. Tinsley. Good morning to you. Thank you for your patience. I did receive your objections to that writ of garnishment. That garnishment, of course, is based upon a judgment that was entered against you on the 3rd of August of 2021. That judgment is for $4,636.02. You said the funds are properly or property is exempt from garnishment. What are you trying to tell me about this? Go ahead.
Okay. First off, Judge, they didn't have my correct address, and I don't understand why. Because I never stayed at 4956 Lanoux Street. Excuse me, Judge. I got COVID, so it's hard over here. So I never stayed there. So they never served me. I got something in the mail with my address on it, and then another paper with the Lanoux address. But I don't file taxes because I'm disabled. And then the rest of that car on my credit is saying that I still owe $33,000. Well, we still owe $33,000 and some change. And my cousin filed it under her bankruptcy because she was on the car with me. And I just got the case number from her because she was when I was down there filing, she couldn't find it. But on my credit report now because they took it off. Because they said it was filed under bankruptcy. Now it's back on my credit saying I owe 33,000 and some change.
Well, certainly, the judgment here, you would not owe anywhere near that amount of money, number one. Number two, the fact that another person that might have been on this file for bankruptcy, that would not discharge you, because bankruptcy, of course, that's an individual thing.
Okay.
So you might want to, you would want to file some type of protest to your credit reporting that has you owing that amount, because the judgment in this case is nowhere near that.
Okay.
It's $4,400. The challenge today is that there is an effort to collect anything that you may have coming back from the state of Michigan. You're not expecting any money from the state of Michigan, correct?
Correct.
Well, of course, if you hit the lottery, it would affect that. You know that, right?
Yeah, I don't even play the lottery. I'm not that lucky.
Okay. All right. All right. So it seems like this is first of all, it doesn't seem like there's a valid objection here. You're right that an address was used on Lanoon Street, but what happened ultimately is that the court allowed service by alternate means. So it allowed service by posting and by other means, and that's how jurisdiction was gained in order to be able to move forward with this case. It sounds like to me that there's actually some money that's owed. You could file against this judgment and try to get it set aside. You have the right under law to do that if you wish to do so. But as long as that judgment is in place, the plaintiff can attempt.
Sorry, Judge, can you repeat that?
I said that you can, if you believe that the judgment should not have been entered, you do have the right to file motions to try to address that issue, to have it set aside. But that's not in front of me today, only the objections to the garnishment. And I don't see a valid basis for the garnishment, but given that you do not receive any money from the state, then they won't be able to take anything if there's not anything there.
Okay.
So I'll find the objections are invalid and I'll release any funds withheld. And again, if there are no funds withheld, then this won't affect you in any way. Understand?
Yes.
Ms. Tinsley?
Yes,
so
sir.
You'll get a copy of my my order denying the objection, because that's the only way that this case could come out. And again, you might want to send something to the credit reporting agencies, even send them a copy of the judgment to let them know that you don't owe anywhere near some $1,000. That's got to be an act, at least on this case.
Okay.
All right.
Yes, I don't owe nothing. Okay.
All right. I wish you well, ma'am. Thank you. Okay.
Thank you.
Thank you, Honor. I appreciate it. And thank you for holding it down for the colloquy challenge in the legal profession.
Thank you. Yes, sir. Thank you. Appreciate it.
You have a good one.
All right. This is case number 22-178147. This is Carmoni Auto Finance LLC versus Denise R. Furman. The matter is before the court on the filing of objection to a writ of garnishment. And I've noted the objections, specifically making reference to a bankruptcy proceeding. It also states issues of improper service and wrong jurisdiction. Those issues are not before the court on the garnishment. If that is an objection that the defendant has, then she would have to raise that in another setting. The issue that there is a bankruptcy discharge is a critical issue in this case. Your appearance for the plaintiff, please.
Your Honor, if I may, is this Midland Funding versus Crutcher? Last three digits, 415?
No, this is Carmoni Auto versus Denise Furman.
I apologize, Your Honor.
No problem. Yours, I do have yours next. It's
Thank
the
you,
next
sir.
one. All right, thank you, sir. All right, so do I have Mr. Katz's office on Carmoni versus Finance? All right, do I have Ms. Furman here? Good morning, Ms. Furman. you're on mute and I can't hear you. So take your device off of mute, ma'am.
Good morning. How are you, Your Honor?
I'm good, Ms. Furman. I've looked at your objections to the garnishment regarding Flexingate. Flexingate, is that your employer?
Yes.
Okay. All right. So you know that there is a judgment against you. That judgment is for May. Looks like the date is kind of smeared on here. Let me see what it is. Yeah, it looks like 6/29/22, and the judgment amount is $11,997.08. That's why there is a garnishment that's been filed against you. You said that tell me about the bankruptcy.
I filed bankruptcy, and Carmona was in there. Also, I never received anything from them because I've been gone from running for for a while now, a few years now, and I've been at my job for 5 years. So I'm not understanding why I didn't receive anything there. The first thing that I received there was payments are going to be taken out.
Yeah, the court allowed for service by alternate means by posting at that location. And that's how ultimately it ended up as a judgment against you, because the court did allow for alternate means. And if you wish to challenge that, then you have to file motions in order to do that. So the court allowed alternative service, and that alternative service resulted in ultimately a finding that you've been served, and then ultimately the entry of the judgment. Now, when you say you filed a petition in bankruptcy, ma'am, did you receive a discharge that discharged this debt?
I didn't look in there, to see it, but it was not, I never seen it coming up. So I'm assuming that, it was discharged also.
No, you'd have to.
Anything that.
You'd have to look on your bankruptcy paperwork to see if, number one, if you received a discharge in bankruptcy. If the case was not dismissed or something, it went all the way to the place where you got a discharge of debts. And then with the discharge of debts, you would have to see whether or not Carmoni Auto Finance LLC is listed on there. And if they're listed on there and the debt was discharged, then they would not have the right to proceed on this. So you need to get your bankruptcy paperwork to take a look at that, to see if that's the case, because if it's discharged with bankruptcy, then that would be the end of this case, unless you reaffirmed it some kind of way.
So that's okay just to serve me, at my job that I've been at over 5 years, and not, take no other initiative steps to, let me know that beforehand to get prepared for that. So you just, I'm sorry.
You're asking a couple of questions. One, the underlying case, the judge in the underlying case allowed for alternate service. That means that they couldn't reach you in their efforts to serve you, and the court then allowed for alternate means, and they were able to post it. That's how they got the judgment. When it comes to the garnishment, they don't notify anybody but the employer. The employer gets the information, and because it's the element of surprise, they have the right to do it that way under the court rules. So that's what happened in that regard.
Not to speak with nobody to resolve, to just take out.
You could always call that office and try to get it resolved, but they don't have to. Once you or me or anybody have a judgment, if you have a judgment against someone else, you don't have to try to resolve it with them. You could go straight after trying to collect assets. You could attack their bank account, you could seek a order to take possessions from them, etc. That's how powerful a judgment is. So in dealing with this issue, unless you have a petition or a discharge in bankruptcy, I don't think that you raised a valid defense before me today. How much money is being taken under the garnishment? Let's deal with that part.
like 300, close to 400, 200. It depends on, what I get a week. But it looks like I'm splitting it with them.
All right, so you get paid every week or every other week?
Yes, every week. Yes,
So every week is between what, 250 and 350 or?
yes,
So your garnishment is roughly about $1,200 a month, right?
yes.
All right, ma'am. So what you probably, I don't see a valid objection to the garnishment, but you're probably entitled to some kind of relief. I'm looking here, just one moment.
Okay.
Yeah, I looked at your notice of Chapter 7 bankruptcy case. But I did see with that a bankruptcy discharge. What you would need is a discharge. That would, and you may have gotten one. You need to speak with the lawyer that you dealt with there. And see if there's a discharge.
Okay.
But in the meantime, let's talk about how you could pay this thing. I mean, it could stay under the garnishment. That's going to take $1,200 a month. Or do you have some amount that you like to pay voluntarily on a monthly basis? And then I lift the garnishment. As long as you pay the voluntary amount, then the garnishment would be in place.
I can try to at least do 100 a month because between my living and, my car issues and getting back and forth to work.
All right. So I don't think that I can set your payment that low, but I can certainly get you a long way away from 1,200. How about that?
Okay.
All right. See how much you judgment. Yeah, that's it. All right, so ma'am, I'm going to set the payment at $200 a month, and I'll allow you to start that payment the 6th of January at $200 a month. I'm going to send you paperwork that you'll take to your employer, and that will stop the garnishment. It will suspend it. Then you begin paying for $200 a month on January 6th. And as long as you make that payment the first Friday of the month, then that will keep the garnishment in suspension. Of course, if you stop the payment, then the garnishment the suspension will be lifted, and then you have to deal with the garnishment. You understand?
Yes.
So any funds withheld, I am going to release them to the plan. And I'm going to suspend the withholding. And I'm going to enter a partial payment order, just like I pointed out. You get all of that in the mail. Understand?
I'm sorry, I didn't hear the last part.
Okay, I'm going to get all of the stuff to you in the mail. You understand now?
Yes.
All right. All right. I wish you well.
Thank you. Okay.
Right.
Thank you so much.
Thank you.
You have a good day.
Let's work on the council. All right, this is case number 421784115. This is Midland Funding LLC versus Devering Clutcher. The matter is before the court, and I'm filing an objection to a writ of garnishment. The record should reflect that a judgment was entered in this case on the 1st of July 2022 for $966. Your appearance for Midland Funding, please.
David R. Monroe, P18081, appearance counsel for Marie Smith, counsel for Midland Funding.
All right, thank you, counsel, and good morning to you, sir. Thank you for your patience. You've heard a lot this morning. I don't know how we finally got down to yours, but here we are. Let me
Thank
see
you.
if I have Crutcher on this Zoom. If you're there somewhere, Deveran Crutcher, if you're on the Zoom, please say something at this time. All right. It looks like the petitioner has not appeared regarding this matter. Looking at the objections to the garnishment, it says that this is not a valid debt and I do not owe yet the entity. The problem is, of course, that there is a judgment that says the opposite. So with the petitioner not appearing and there seeming to be an objection that does not conform to the law, and there's no validity to it, the court will find the objection invalid, immediately release any funds withheld to the plaintiff, and the garnishment will continue under these circumstances. It's so ordered at this time.
Thank you, Your Honor, and the court will send that to counsel of record.
That's correct, counsel. Thank you. Good day.
Thank you. I want to tell the court how much I appreciate your hard work. Thank you, sir.
Thank you, sir. I appreciate that, sir.
Good day.
And Mr. Nate, looks like you're on Citibank, correct?
Yes, Citibank and Alice Knox.
Oh, yeah, got you. Case number 22-178-778. This is Citibank versus Alice Knox. Knox, the matters before the court set on for review on today's date. Counsel, your appearance at this time.
Preston Nate, P77884, appearing for Citibank.
Thank you, counsel. Do I have Alice Knox on the Zoom? KNOX, Alice Knox. I think she was here the last time. Update, if you will, if you call.
Yeah, and now I can give you an update. I think there was actually counsel for the other side, Brian Parker, but we did get a consent judgment. I think we kicked it out to today just to make sure we had enough time. I did try to email that over to the court. I think, I'm not sure if I got the right email address, but we did get a signed consent judgment back.
Yeah, let me give you another place to send it. Can you send it to Carmen, C-A-R-M-E-N, Carmen.Banks, B-A-N-K-S, at 36districtcourt.org.
Court.org. Okay. I'll send that over right now, but everything should be resolved. Looks good on our end, so we'll get that into the court.
All right, thank you, sir. Appreciate it.
You bet. Thanks, Your Honor.
Good to see you.
You too. Yep.
All right, in the court clause case number 21-16-1958. This is RT Homes versus Queen Blue. Court calls 21-16-1988. RT Homes versus Tia Blair. The court calls 21-161-943 RT Holmes versus Michelle Munger. The court calls RT Holmes versus Ardrina Banks under the file 21-161-973. These matters, together with matters called earlier by the court, all with the preface RT Holmes. The court set every one of those matters over for hearing on today's date, as they had a common issue where the petitioner, RT Holmes, was seeking to set aside the order of dismissal and to have the cases reinstated. The court reviewed these matters and looked at these matters. It appeared that the complaint in each matter did not even really set forth a cause of action, that somehow in each of these matters a default was entered, and that a judgment was entered on the default, and then ultimately various cases were dismissed for failure to provide proof of service. I set it up for each of them for hearing, so that the RT Homes, whoever that is, whether it is a corporate entity or some individual, the court cannot know because the complaints do not describe what type of entity this is. And as stated before, information set forth on the complaint does not really allege a cause of action. And just by way of example, in each matter, the complaint is basically the same and says the defendant is a resident of Detroit, Wayne County. The defendant, number 2, is indebted in the sum of $1,613 as a result of express or implied contract by and between the parties. The plaintiff has completed performance of said contract. And although often requested, the defendant has failed or refused to pay. It does not describe any activity or action. It does not attach a contract. It does not describe what service was performed or what product was sold. Nothing. For that reason, the motion for reinstatement of these matters will be denied in each and every one. So the court also caused 22-19-7760 Crystal Walters versus Branch. This appears to be a motion for possession pending judgment. The court did set it on for hearing on today's date, and no one appeared. Therefore, the motion for possession pending judgment will be denied.